good, better, best practices. This is what it is. I think they'll stand for themselves, but I am learning and growing as we do this, and I've adapted my styles. But I think here's some good examples of ones I've found and done. Um, so this is a pretty simple narrative here. The purpose of the survey was to establish the location of the retaining wall on the easterly line of the subject property. The wall leaned a little bit. They want to know who was responsible for maintaining it. So this was, for me, a fairly simple one. I found a rivet on the northwest corner of the subject parcel and found section corners and witness corners, as I noted on my map. Holding those, everything occupation lines. And so just a quick example of that. Here's the retaining wall on the neighbor's property. I can kind of show how these fences fit. The found rivet here, and set a rivet here. So could I have done a little bit more in-depth narrative? Absolutely. I think it fit kind of what the intent and what I found out there was, but that was one example of a narrative. Here is one that just got filed in a neighboring county here that just got sent to me next to a survey I've done. So this isn't my narrative, but I kind of like what they have here. And so they even went through what equipment they used, how they did their setup, what records of survey they used and examined. And then they went through and talked about there's some ambiguities here, some gaps in parcels, and how he determined what was senior and how he determined where he placed and how he placed his line to take that gap in this case. And then a map to match that. And then let's see. Here's just another one. This survey was ordered by Wesley West to remonument his property corners. This is in an old lot and block area in northern Utah. Multiple fences near the center of block were used to reestablish the Smithfield City survey, which dates back to like the 1880s. Done by the survey done by Hanson in 2019 was held to reestablish the street. The block was found to be long from north to south, and a fence line along the south line of Lot 8 was held as the original lot line. Lots 7 and 8 were each given a proportional amount of the surplus. There are a few possession lines in this immediate area that do not match deed records as shown. These possession lines are dimensioned hereon. A boundary line agreement was negotiated and created for the west line of the subject parcel. And then this was what set stamped. And so they've got a great exhibit here of how the fences fit areas, didn't fit areas, and how they came all that together. So as you read through this, you kind of understand the thought process that the surveyor was or wasn't going through on this. And so kind of a good, better, best example there through three different surveyors.
Yeah, those are always helps make the map defendable, right? That's kind of always what I always kind of push as well. So anything you can add, survey notes, whatever the case may be, but
Yep, I've seen some that, I mean, we've talked about Indiana's requirements
yep.
being some of the most robust, but I've seen some of these that are the second page of a survey is just all sorts of notes and details, depending on the complexity or the simplicity of the survey and what you do need to defend or how you would defend that. On a personal note, I'm always a big fan of, even on a simple lot survey, showing the improvements around there if there are any. That gives clarity to what you're talking about. I hate seeing a survey that I know there's fences improvements and all they're showing is deed lines. It doesn't give perspective. It doesn't help the landowner see what they're doing. And so the picture is as much of a narrative as the written narrative itself. It ties it all together and let someone see how it fits on the ground. Any questions about narratives or anything like that? I hope that helped answer the question and give a couple examples there.
I was going to look up, I know we had, I think we had Gary do survey reports on mentoring. I was just gonna find that really quick on that week, but that was a good episode to talk about the narratives that go on.
Get into that one. Okay.
Yeah.
Well, if you find that, throw that in the chat and we can all look at it. So
Yep.
I am just getting over a cold, so I apologize if I sound overstuffed and nasally today. I was out for the count over the weekend and just getting back into it. But um, Jeff, welcome back. Did you, by any chance, get a watch last time's session? Have any comments, updates, or anything you would want to add to the last half of chapter 3, just to clarify there before we jump into chapter 4?
I did not get a chance to look at, it wasn't last, the week before last, right?
Yeah, 2 weeks
Yeah.
ago. Yeah.
Yeah.
Yeah, 2 weeks ago. I did not get a chance to look at it,
Yep.
All right.
but, kind of forgot where we left off.
So when we were with you last time, we got through the first half of chapter 3. We finished off the last half of chapter 3 2 weeks ago, and ready to jump into chapter 4 now.
I don't know, unless somebody has a particular question for me, I'm ready to move on.
Okay. We'll do that. Okay, so chapter 4, property rights and title to property. And so I'm going to start off just asking Jeff a question here. I mean, we've gone through some of the basics and we're building on every chapter here, the next thing. So we talked about our duties. We talked about following the footsteps. How do we survey and respect the history? We got into chapter 3, talked a lot about deeds and the parts of what's in a deed, how to read the deed. And now we're getting into property rights and title. And this is always that gray area where I think surveyors start shutting down and separating, because property rights and title property, well, that's not our arena, right? And so I want to throw out the question, Jeff, how come this chapter? What were you trying to convey to surveyors to set up for the next chapter to close out the previous chapters? Why do a whole chapter on property rights?
Well, and really, when I went back and read it, I don't really talk a whole lot about property rights. I might need to rename the chapter. Well, see, the term property, at least as far as my career goes, we weren't supposed to know anything about property rights. I mean, we have nothing to do with property rights. But in the final analysis, that's the business that we're in. I mean, I've come to realize that over the years. There's a piece of real property, and the piece of real property that someone buys, it has associated rights. In law school, we talked about those as being the bundle of rights that come along with property. And you can sell some of those rights, you can lease out some of those rights, um, you can burden the property in various and sundry ways, but the property comes with rights, and those rights are not unfettered. They have boundaries, okay, and then that's a property boundary. The extent of the rights is where the property boundary is, and as a profession, we don't even call it a property boundary. If you look at in our various and sundry definition of surveying, we talk about this nebulous thing called a boundary. We don't call it a property boundary, and we still have people even to this day, writing articles and various things about how surveyors can't determine what people own. In the final analysis, if you properly retrace well, first of all, back up just a little bit. We'll talk about boundary establishment next time around, I guess, in chapter 5. But boundaries, by and large, are already established on the ground. Okay, and as a retracement surveyor, our goal is to find where those property boundaries have become established on the ground. And this is something that we've run away from as a profession. But if you follow correct retracement theory, and you find where the boundary line has become established on the ground, then you have done nothing less than show your client or whoever the stakeholder is the limits of that ownership. Because and when we talk about the boundary establishment doctrines, which will be next time around, like just take the doctrine of monuments. Okay, what is the underlying premise? What is the underlying presumption of the doctrine of monuments? The underlying presumption is that when the monuments are in the ground at the time of the conveyance, the grantor and the grantee walk the bounds, what Robillard used to call beating the bounds, and they would walk they are presumed to have walked the boundaries and accept the boundaries, and the grantor is selling the dirt surrounded by those monuments that are in the ground. The monuments are tangible things that the people can see. And when they accept it and go into reliance on those monuments, that's where the property rights attach. The property rights attach to those monuments and the lines and the boundary lines that are drawn between, through those monuments. So when you say surveyors don't show people, what they own, that's exactly what they think that we're doing. Even Brown coughed that one up in his 1979 column that he wrote for the Surveying and Mapping magazine. The land surveyor's liability to unwritten rights. Even Brown realized that that's what most people want. And matter of fact, he changed his mind in that. He changed after he wrote that article. He was actually accused of being a fence line surveyor when he was had been the father of deed staking. So a deed staking doesn't really do anything for anybody, except maybe the surveyor. It makes the job easier. But if you follow proper retracement theory, you do nothing less than identify the limits of the ownership, where the property rights are. And if we're not in the property rights business, then what business are we in?
Okay, thanks, Jeff. I appreciate that. So maybe give a rundown here, and to add to what's in here is, the rights to the property, if I will, come from the government at patent, right? Their government owns it, they patent it to the first person, and they have a right now to a tract of land. And then in the first paragraph here, it says the enforcement mechanism. I'll start at the beginning of the paragraph. No discussion of property rights can begin without an understanding of where those rights originate. Again, we talk about the government, the patentee, and then passed down to their successors and assigns, right? No discussion of property rights can begin without an understanding of where those rights originate and how they will be enforced. The primary enforcement mechanism of the state when it comes to real property and the rights associated with the ownership of the land is the courts. When there has been a violation of those rights, we talked about in the previous chapter, no one has necessarily committed a crime, but generally speaking, torts may have been committed, and it will be up to the courts to determine who is right and who is wrong. The court obtains jurisdiction over the people involved in the dispute or over the land in question. And so in this retracement discussion, we find some discrepancy, there's a dispute between landowners, whatever it is, and so there needs to be a resolution to this. I think this is where, and even in this line, Jeff, I agree with what's being said here, but this is where all of a sudden our surveyors, we back away, right? Because we can lean on this. Well, it's not our decision to make it. It's the court, so I'm going to stop, right? This isn't mine. And but landowners rely as professionals, they rely on us to make determinations and help solve this and be mediators. And so I love that we go next into equity. I had a great discussion with a client today that called up, and I did a survey for them a couple of years ago. The land's been in family land for 80 some odd years, right? They've had it forever. About 25 years ago or so, they did a subdivision of the land into a lot and a remnant parcel. And so when I went a couple years ago to now split the remnant parcel, we did our survey, we did our retracement, we went and located the section corners, we walked around the perimeter of the property, and we found all but 2 property corners in. All the original monuments, the old rebar from 25 years ago, and even some of the older monuments from before that. So in my mind, it's really cut and dry what their rights, the bounds to their rights are, right? We found the old ones, and I can explain that on the face of the survey, but someone else came in behind and said, hey, there's a gap here, or this here, and they're starting to set other property corners and determine things, and in my mind, what I can defend, again, that 51% is I found all the original monuments. I can see the intent. It's very clear to me. And so we had a discussion about, they came to me, it's like, well, do I have rights to this land outside of this monument that's always been there? And so we got into this discussion about equity. I love this idea. In a lot of my life and politics and everything, I've always stayed pretty middle of the road. I try and look at both sides. And so equity really rings true with me when I have these discussions with landowners of, well, what did you think you owned? And just because I come in and say, I think you own more, do you really? Let's stop and look at the rest of the story and the rest of the evidence here. And so with equity,
Well, there's a lot more, like I've said it, I think a couple of times, one of the reasons I'm doing this is I haven't gone back through this book in a while, but there's a lot I could add into this chapter here and about equity. When you hear our surveying patriarchs talk about the surveyor as a judge, um, that's where equity comes in, because the surveyor, it does have as Cooley put it, a quasi judicial function, but not as a law judge, but as an equity judge. And so there's a difference between the law and equity. The law is the law, and equity isn't the law, and the law is not necessarily equitable. But equity is what's fair and what's right. And a pure boundary dispute case, where we're not arguing adverse possession, we're not arguing over the title. There's 2 parts to any boundary resolution. The first part is, what is the property? That's the legal question. It's lot 9, Garfunkel subdivision. That's what it is. The question, the equity question, the factual question, and equity deals with facts, it doesn't deal with the law. The factual question is, well, where on God's green earth is lot 9 located? That factual question is the surveyor's question. That's really the only question we have to answer. And we're the only people in the United States of America who can give an answer to that question in the first instance. A judge can't do that. A judge has to have a case, has to have litigation, has to have in personam jurisdiction over the parties. And and the fact that not every boundary has been surveyed, but generally speaking, every boundary has already become established on the ground, and that's our work. That's the work we're supposed to do. And a lot of people say, well, Jeff, how is it that every boundary in the state of Nevada and Alabama, the vast majority of them, if not all of them, have become established on the ground? And the proof of that is, take any boundary dispute to court and see how many boundary lines you come out with. You're going to come out with one. And that's with or without surveying activity. Surveyors aren't needed when you go to court. They are deemed helpful, and we get called on many occasions to come into court as expert witnesses. But all a judge needs to make a boundary determination, or really any civil case gets solved. All the judge for to get solved, all the judge needs is subject matter jurisdiction. You got to be in the right court, and all the judge needs is a plaintiff and a defendant. That papers get filed, the defendant files an answer, and it's all submitted into court. And now the judge, whoever that judge is, has in personam jurisdiction over these people. You can't have your rights adjudicated without a due process of law. That's a constitutional issue. And they don't even need lawyers. Nobody is necessary to file, and if a boundary dispute goes to court, nobody's necessary except for the judge and the plaintiff and the defendant. Three people. That's all you need, and they will solve the boundary location. And how are they going to do that? Because it's already become established on the ground through state law and through equity. It's already become established on the ground. That's our job, to go find where that boundary has been established on the ground. That's how you do it. That's the only job we have, really. And too many people think that somehow that's practicing the law. I mean, I've been accused of trying to tell surveyors how to be attorneys, but answering factual questions has nothing to do with the law. And the and that is why you have to take a boundary dispute case to the right court with subject matter jurisdiction, not only law jurisdiction, but with equity jurisdiction as well. And I did misspeak in here in this chapter. I have a mistake in there. I said there are no more equity courts. There are equity courts. I guess I was in a fog when I was writing this thing. Your chancery courts across the country are equity courts. And in many states, a boundary dispute starts in the chancery court. And you don't even have to be a lawyer to be a chancellor. You don't have to be a lawyer to be a probate judge. Those are equity courts as well. And in some states, the original jurisdiction for a boundary dispute case is in the equity court. Why? Because there's not a legal question. We're not dealing with legal questions unless, of course, somebody's arguing adverse possession, and the attorneys, that's their go-to in boundary disputes. Their go-to is to go with adverse possession because they can read the statute. They understand if they get all of the elements proved in court, then they're gonna not only resolve whatever kind of dispute they're having, they're also going to determine they're going to either the title to both properties will be changed, or the title will remain the same, and they're going to resolve where the location of the property is. Limits of ownership. Let's go ahead and
So,
put it that.
Jeff, maybe to help us clarify a couple of things before we get going too far into this, you're talking about the different courts and the subject matter jurisdiction and the chancellor court or something like that. Could you maybe give us a rundown of what the different court levels are and who would have that? You know, what's a chancellor and equity court, and where does that fall in the hierarchy of courts? Maybe something that hasn't dealt with the court, so we could understand kind of where you're talking about when you talk about these different types of courts.
Okay, well, we'll start at the bottom, like municipal court or traffic court. You know, those are law courts. Those judges don't have equity jurisdiction. All they can do is dispense the law. And then you get up to, and I'm going to stay in the civil context, but there are a lot of these lower courts. In my state, they would be called district courts. Out west, your district courts are your higher level courts. But the trial courts, the lower ranking trial courts only have law jurisdiction. And then as you get up to your higher level courts, right before your courts of appeal, in the state of they're all a little different, but in my state of Alabama, we have district trial courts, and then after the district trial courts, we have our circuit courts. Okay, And then the next step after circuit courts is an appeal, your appellate courts. So that higher level, and I know in Idaho and some of the western states, those are called district courts. So they're not all named the same, but that last trial level before you go up on appeal, those are your higher ranking courts, and they generally speaking have both equity and law jurisdiction. All of your appellate courts have equity and law jurisdiction, and of course, your Supreme Courts in your states have equity and law jurisdiction as well. And they have to, so people will come to them for complete relief on whatever their issue is. Now, so in this country, we never in England we had two sets of courts. They had two sets of courts. They had the law courts, the common law courts, and they had the Chancery Court. And the Chancery Court was set up by I think it was James the First, maybe set him up, and he appointed the Archbishop of Canterbury, his secretary, to run those courts, and they were just equity courts because the law didn't have remedies for these for a lot of situations that came into the common law courts. There was no law being broken. There was no law to dispense, and so they would shoo them away. Get out of here. We can't help you. And they were crying to the king, "Hey, we got to get some relief." So the Archbishop of Canterbury set up the Chancery Courts and started dispensing equity. And but here in the United States of America, some of the states have set up two separate courts, the law courts and the equity courts. My state has probate courts; those are the equity courts. Tennessee, just north of us here, they have chancery courts and they have the law courts. But these equity courts, the chancery courts and the probate courts, um, primarily deal with equity, and in many cases, they have original jurisdiction over boundary disputes because a boundary dispute, unless you're arguing the title, a boundary dispute, there are no legal arguments. We're just talking about a location issue.
So these district courts and these equitable courts, those are generally then state run, state level courts that
State
you're
level,
dealing with.
right, right. Now, the federal government, the United States Supreme Court, of course, is a court of equity as well as a court of law. But it has limited jurisdiction. It can only deal with, the Constitution of the United States and federal laws and treaties, and they have original jurisdiction over boundary disputes between states. So because they're an equity court, but they are a court of limited jurisdiction. But we even though we didn't have the separate courts at the federal level and in some states, the jurisdiction still there's a separation in the jurisdiction between law courts, dispensing the law and doing equity.
Okay, thanks. Does anyone have any other questions about courts or kind of discussion we've been having? That's a lot to digest, and we'll make sure we have.
I'll bring up one thing. In Arkansas, at one time, we did have chancery courts. Now we only have district courts and appellate courts, the Supreme Court. But one thing there that I'd like to mention, and I don't know whether this is true in other states or not, but in Arkansas, the Office of the Courts produces what's called a bench book. And this is a set of instructions for all judges for a particular court. And if you have questions about what a court is going to do or what their authority is, get a copy of your bench book for the court you're dealing with, and you'll know exactly what your judge is duty, what his duty is, and that will be helpful.
Most state legislatures and you can go on your state legislature's website and find your statutes, your code, your statutory code, and usually there'll be one that says, courts. It deals with the courts. There's a lot of good information if you just browse around in your on your state legislature's website and find your code sections, statutory codes. There's usually something about property. Property rights come from the state; they don't come from the federal government. And even when the federal government's involved, um, it's in a property issue. The situs state, the state where the property is where jurisdiction lies. And so these federal courts that are out there, they'll have to, if it's a boundary, if it's something to do with property, they have to apply local state law. So your property rights don't come from the Constitution of the United States. Now they can't. Constitution keeps them from taking your property, except under certain situations, just compensation, due process of law, that kind of thing. But property rights come from the state, not the federal government, by the way.
Thank you. In fact, we read that in the first paragraph there as well, where the property rights come from. So jumping back into the book here, Black defines equity as justice is administered according to fairness, is contrasted with the strictly formulated rules of common law. We've gone through kind of the difference in equity there. I do like this maxims of equity that's in here. Some, one who seeks equity must do equity. The maxim is an application of the broader doctrine ex turpi causa non aritur actio. No action arises out of an illegal consideration or transaction. It says perhaps the earliest application of the underlying principle is found in the famous case of the highwayman. It is stated that Lord Kenyon once said, by way of illustration, that he would not take account between two robbers on Hounslow Heath, and it was questioned whether the legend in regard to the highwayman did not arise from the saying. It seems, however, that the case was a real one. He did file a bill in equity for an accounting against a partner, although it was no sooner filed and its real nature discovered than it was dismissed with costs, and the solicitors for the plaintiff were summarily dealt with by the court as for contempt in bringing such a case. Number two, one who comes...
There's no honor among thieves, Trent. No honor among thieves.
Yep. One who comes into equity must come with clean hands. Equity aids the vigilant, not those who slumber on their rights. Unconscionable delay. Equity acts in personam. Equity follows the law. Equity delights to do justice and not by halves. Equity will not suffer a wrong to be without a remedy. See also ubi jus ibi remedium. Where there is a right, there is a remedy, and lex semper dabit remedium. The law always gives a remedy. Equity regards as done that which ought to be done. Equity regards substance rather than form. Equity imputes.
I tell my daughter she's not equitable with some of her purchases because she has white furniture. She has 3 kids, 2 dogs, and a husband. She doesn't understand equity. She puts form. She puts a form above substance.
Sounds like architects too, right?
Yeah.
The discussion, I have a 10-year-old daughter, and everything. Life is never fair for her right now, no matter what we do, right?
Yeah.
Equity imputes an intent to fulfill an obligation. Equality is equity. Between equal equities, the law will prevail. Between equal equities, the first in order of time shall prevail. Equity abhors a forfeiture. Equity will not aid a volunteer. So just some things to consider there about equity.
And you see that if you read enough cases, you see these maxims of equity in action. And also we have some equitable principles underlying some of our some other things, like first in order of time shall prevail. You know, that sounds like our recording statutes. First to the courthouse wins. What's the other one? Abhors of forfeiture. I've seen a case go on that one right there. There were no Miller had no heirs, and without heirs, the property was going to escheat to the state. But the court said, you know what? Equity abhors the forfeiture, and therefore the greater estate will pass. So anyway.
Okay, well, I think that's a great segue into the next section, because we actually talk about the recording statutes and the first to record and some of those, the statute of frauds there. So just to finish out in 4.04 here, courts of law and equity, I think we've covered this material really well. I'm just going to read the last paragraph in this section here. It says, a pure boundary dispute case with no other issues, no crimes, torts, constitutional issues, or statutes in play, right? It's just a question of boundary, is an equity case, and only courts having equal equity jurisdiction can hear this case. We've talked about that. We said that here tonight. The professional land surveyor should be aware of these distinctions in court jurisdiction. The surveyor should also be cognizant of the maxims of equity. In the final analysis, most boundary dispute cases boil down to a common sense and the dispensation of equity. Prior cases on the same subject will generally be followed by subsequent courts, and familiarity with the common law is essential for the practitioner. And so, getting back to the name of this book and what we're trying to talk about is the Pincushion Effect. How equitable, how fair is it for a surveyor to come in and set a second or a third or a fourth pincushion, right? That's really, to quote, my daughter, well, that's just not fair, right? And so this idea of having equity, having fairness rule, what service do we do the public when we go do that? That's just not fair to the public. And there's no equity in that. So I really like this idea of equity relating to the Pincushion Effect. I just wanted to point that out. And just in a 10-year-old's mind, that's just not fair. It really isn't. And we should have landowners rolling and screaming on the ground, right? That it's just not fair that we do that. Martina, you've got your hand up.
I do. I love this chapter, and I know it's a short chapter, but this whole thing about equity really hits home for me as a surveyor. What if you find a rebar and cap, and let's say in my opinion, I'll speak for myself. In my opinion, I think it's wrong by about 30 feet. But we all know that the corner is the corner is the corner. The rebar is the corner. That's the only thing that landowners can rely on. Jeff tells us that. Jeff Lucas, John Stahl tells us this. How is that rebar and cap set by another surveyor before me that might be wrong by 30 feet, which is substantial? How is that fair? That's my question. Go.
It's a great question, right? So what's fair? Let me answer that, and I'll let the experts jump in a little bit more. But what's fair is what your action is next, right? It may not be fair to one landowner or the other, but what is fair is your next step. Because we talked about this the last couple of times we've met, that red flag, right? We find that, well, what's fair is, as a professional, your ethical obligation is to be fair and find what evidence you're missing. Is there something we don't have that lends credence to that monument? Or, is it fair then you defend your client and call up the other surveyor and ask them those questions or do more research? That's, in my mind, where equity and fairness comes in, is we've got to be fair and not just reject it or accept it, but find out an answer that we may not have yet.
Great answer. And I've already done parts 1 and 2. I'm working on contacting the surveyor. And yes, we are finding, well, I don't want to go in the weeds because I don't want to disparage, but we're gonna do more to prove fairness. So I love that answer. So thanks.
Great. Wonderful
Now,
question.
I'm going to say something here. When I first started my study of law in 1972, I stood on the steps of the University of Arkansas Little Rock Law Library. And without being a law student, I had no idea whether I could get in the door or not. But I decided that it was important that I did. And I marched up there, and sure enough, they let me in. They wouldn't let me take any books out, but they'd let me study anything I wanted to. And the first and the hardest thing for me was to understand that fairness really has no play in law. Equity does in a limited thing, but it's not fairness. It's something else. And when I studied Chancery Court and district courts, one of them dealt with equitable things like divorce and partnerships and land boundaries where there was an element of equity between the parties, where it was two lots adjoining lots of a subdivision or something like that. But the district court dealt with boundaries that were decided by law. And so there were two different things there, and you need to understand both of them. And law is just that, law. It doesn't necessarily come out something that we would call fairness, because fairness is a subjective thing. Fairness means different things to different people, but the law is consistent. You go by what was precedent, and that in itself is where the fairness is. If it's not fair, it's not fair. That's just the way it is. So you want to look at that, and then so whenever it comes to equity, there you need to decide whether there is an element of equity between the in the squabble. If it's senior junior rights, the senior right is gonna argue for a law determination, and that's correct, because if he can prove that by law he owns the property, then he need not make any provision for the adjoiner to have any part of what he owns. But in equity, when you have two lot owners side by side, and there was a mistake in the original survey, and there's not as much land as what's shown on the plat, or there's more land, then it comes into the element of equity between these two, and you have to proportion that part that is either in a negative or a positive thing. So
I think that's a fair point. I probably ought to use a little bit more precision in my language. I was using fairness as an illustration. I kind of leaned into the example of my daughter saying that's just not fair. But in reality, it's never going to be fair. Someone's going to feel slighted or harmed in whatever decision comes in, and that is the role of law and justice in it, right? That really is a clear-cut thing. So I appreciate that the distinction that's made there, and and precision in language is important in there. John threw into the chat here, return to Martina's question there. One of the questions that does arise is, was the monument relied upon by the owners, right? Is there a reliance? And that's a question of the, further evidence to have there. But John, do you care to add any more to that, or any thoughts to your comment there?
Well, yeah, anytime you come out and discover that some surveyor has already beat you to the punch and has already been paid to monument the corner that you're seeking, um, you, as a retracement surveyor, you can't fix it if it's broke. You have to accept it if it's done, but we only have to accept it if it has been accepted by the landowners, relied upon by the landowners, and established, those landowners have established their boundary in accordance with that monument. Then that's when it becomes a controlling monument, is after their reliance. So a lot of times we want to test our survey versus the other surveyor. Yeah, I measure this, he measures that. How did he get there? How did I get there? And we end up with this surveyor to surveyor analysis that it completely misses the point. The monument was paid for by a professional was hired to put the monument in the ground. They put it in the ground, right, wrong. Well, they're always wrong by some degree, whether it's by some precision, lack of precision or accuracy, whatever, or even a blunder. But the point is there, and it's not a test of whether or not I agree with that surveyor, their technique, or whatever. It then becomes a question of, okay, after that surveyor left, what did the landowners do? Did the landowners rely upon that position to now establish the improvements that were placed on the ground? Or is it not too late to just fix the problem? But you have to go to the landowners to figure that part of it out. And figure out, well, have you, relied upon this? And it's a lot of it's just the physical, obvious evidence. Have they built fences in accordance with it? Did they use it to measure a 10-foot offset for their side yard setback, whatever? So, and why did they set the point in the first place? Because people usually don't just go around hiring surveyors to do boundary surveys unless they need it for a reason. So all of those kinds of things, you need to have the evidence and gather the evidence for it, and then make sense out of it. And if it's been relied upon and the boundary has become fixed and established, well, retrace it. And yeah, so it's 45 feet off. So whatever, it is where it is, and it is where it's been established by the landowners. It's not a gap, overlap, or title problem. It's a boundary location issue and an evidentiary problem.
Yep, exactly. John, voice of reason, as always. Thanks.
I like it. So it sounds like you're on the right track there, chasing down more evidence.
Thanks, everybody.
Okay. And Kyle threw a what if in here. What if a surveyor locates and sets a record boundary on a block and a homeowner rely on the boundary, and another surveyor later locates multiple monuments around the block and finds significant shortage? Is it equitable to hold the monument set by poor practice? Not a blunder, measurement, or accuracy problem, but an issue between standards. And so it gets into that same reliance. What was the intent? What was the reliance on there? What's happened to it over time?
My biggest problem with just holding the monuments because it was relied upon is you could have multiple surveyors, basically offering to do this work. And the cheapest way to do that work is to hold a record boundary, set the monuments, and the general public just doesn't know any better. And so I don't really necessarily, or at least I have not been convinced that it is indeed equitable to say, hey, I've got the cheapest surveyor in town. They'll do it tomorrow for $50. And yeah, that's where the boundary is. And, I'm going to put the fence there, and then have, even 10 years go by, somebody else comes around the block and, measures the whole thing. And you find, oh man, there's big problems out here. We have these issues between, monuments and ownership. And I don't know what's more equitable there. And that's why I'm always, a little bit less of a person willing to hold just every monument I find.
Absolutely. It gets to that 51%, right? Matthew had his hand up, and then John will continue this discussion a little bit.
Yeah, I had a question for John. Earlier we were talking about, or Jeff was talking about, the assumption is that the buyers of the property viewed these monuments. So how does that fit into when you ask a property owner and talk to a property owner? Have they relied upon this? And you get a negative answer. Does that throw out that assumption? Or how does that assumption play into the scenario you were just laying out?
Let me speak to that if y'all don't mind. It's not an assumption, it's a presumption.
Presumption.
A presumption, I don't know if we talked about this a couple of weeks ago or not, but I'm going to go ahead and talk about it real quick. A presumption is a legal fact until it is proven wrong. As Robillard would say all the time, it's a presumption, but it's rebuttable presumption. So going in, the presumption that the monuments are, and they call it legal fiction, but the presumption underlying the common grantor doctrine and the doctrine of monuments, which are basically the same thing. When the monuments are in the ground at the time of the conveyance, the legal fact is, until somebody proves it wrong, the legal fact is that they walked the bounds, they saw the monuments, the grantor sold the dirt surrounded by the monuments, and the grantee bought the dirt surrounded by the monuments. Now, so that's go as a surveyor, you're going in. Let's just say your survey goes to court, and you're either going to be right or you're going to be wrong. But you will have the legal fact, and you held the monuments. You're going to have the legal facts on your side. And so you're already got the greater evidence, the greater preponderance of the evidence going your way. They are going to have to overcome your presumption, your legal fact, with other facts. So you got to do, you got to do your work, you got to do your homework, and one of the best things to do when I went solo back in 2002, and I got out from behind a desk and went out and started surveying. Number one thing I noticed was all the evidence I was missing from just depending on party chiefs, and then number two, I learned over time is the most important people in this whole equation are the people. And so my MO was, if my client could show me the boundaries before I even got started, that's what I wanted him to do, him or her to do. And then instead of avoiding people in the field, I would actually ask questions or try to seek people out who might have answers. And you can learn a whole lot just by talking to your client. And if they don't know anything about the boundaries, hey, that's why I called you. So maybe the next door neighbor knows something about them. So I would seek people out. I mean, we wouldn't bend over backwards for it, but certainly I would try to get my client to show me what where they think the property lines are, if they were available to do it.
Okay, thank you. Appreciate that, Jeff, and that clarity there. Great questions. John, you had your hand up as well. Is there anything else you wanted to throw in there?
No, Jeff pretty much said everything I was going to say. It's not an assumption, it's a presumption. And they've got the burden to overcome it. Matter of fact, in order to reject that monument that you find in the wrong place, or that's a blunder or whatever, whatever excuse you want to throw at it, you have to have you have to be able to prove that it's in the wrong place. You have to be able to prove that it's never been used or relied upon to establish the boundary. Now, one thing about establishing the boundary, and the whole next chapter I think is on establishment, that what we're talking about here is that it's been relied upon to the degree that it fulfills a legal requirement. Has it been in place for 20 years, acquiesced and treated as a boundary for 20 years, long period of time? Has it been, have substantial improvements been placed in reliance upon it, so that if you were to now move that monument or correct the error, it would cause substantial costs to be incurred to move the sprinklers and the landscaping and all the stuff that's gone on. That's doctrine of the equitable estoppel, which is another equity doctrine. So, and there's 4 or 5 of those different doctrines that the courts have laid down for us to follow. And we need to have enough evidence to show that, yes, this particular doctrine, there is enough evidence, in my opinion, to fulfill that doctrine. Therefore, the boundary has been established in reliance upon that monument, and it is now the boundary. I don't care if it's 45 feet off or whatever. It is what it is, and where it is what the evidence and the facts will tell us. But we've got to be able to apply that rule of law.
Let me just throw something in there on top of what John's talking about. So let's say that you go to court, you've held the monument, and somebody doesn't like it, you go to court, and there's 2 competing surveys. One of them's going to be right, one of them's going to be wrong. That's just the way it is. The judge can't split the baby, because if a judge tries to split the judge is going to have to go, say this is a judge without a jury, or with the jury. They're going to have to go with one surveyor or the other. They can't, they can't go with both, obviously. And they can't rule on evidence that isn't presented in court. So if nobody's talked about splitting the baby, the people could get together and they could mediate, to a different line. That's a different question. But the point I'm trying to make here, Matthew, is when you go to court, you're either going to, let's just say it goes to court and there's going to be a competing survey on the other side. One of you is going to be right and the other one's going to be wrong. That's just the way it's going to be. And all you have to have is more and better. There is no gold standard. The criminal standard of evidence beyond all reasonable doubt, even though it was in that stupid manual for 100 and some odd years, that's the wrong standard. We couldn't convict OJ under that standard. Everybody knows OJ did it, but we couldn't convict him on that standard. That standard was too high. Now he lost all his money in civil court because there was a lower evidence burden. It was going to be the preponderance of the evidence. So you only have to, in grade school you had to get a 70 to pass the test. In civil court, all you got to get is a 51. So, and you got to have more and better evidence than the other side.
So I've got a question here, and this will lead us into the next few portions of this chapter here. But what's next? I think this is a fair discussion to have. Is you have a deed. We're going to talk about the statutes of fraud and recording statutes. You have this deed. It records. It describes the limits of those rights. And it gives. We talk about constructive notice here and some other things in this chapter. But we go out there and we survey it, and for extremity's sake, we find those monuments, the property corners, the pins off by 35 feet. Well, this deed, the 4 corners of the document says this, doesn't match what's on the ground. So what's next? How do we remedy this so that there is this understanding between all parties now that what was in this document does not match what was held and relied to on the ground, which, the title company, we get into this bigger discussion, which is always a little scary for surveyors. But what is next in that case to monument, document, and correct what we find?
It is kind of a shame that, when you think about it, across 50 states, there is no universal answer. It all depends on your state, because property is state specific. Property law is state specific. Everything dealing with property is state specific. There's certain things you can do as a surveyor, other things you can't do as a surveyor. So there's no kind of general, well, we could just go do this, okay? I think it was Mulford in his book, little treatise, Surveying and Boundaries, or something like that, Boundaries and Landmarks. He talks about having conferences with the people and resolving their issues, and then doing some sort of memorial to memorialize that agreement somehow, some way, because the people can if a boundary is in flux, it's questionable, it's in conflict. That's the groundwork for agreements. And if the people can agree, they can go in front of a judge and they can agree to a new boundary line and and mediate it out. And that's not that's not practicing law. If the boundary's confused, and we don't know where it is, there's more than one possible location, or it's in conflict, or you're in court fighting over the boundary, it's in conflict. It's still a factual question as to where the boundary line is located. We're not arguing the title at this point in time. Nobody's arguing the title. So the people can get together and they can decide where they want the boundary.
Okay, John, go ahead.
Yeah, just right on. You can always, you can always resolve it through an agreement between the parties. But from a surveyor's perspective, the simple answer is that you're not the original surveyor. You're retracing, so you've got a retracement hat on, and as a retracing surveyor, you cannot fix it. There's nothing you can do to fix it. All we have is a burden or the responsibility to document it. So you say, yeah, I found this monument. Here's the evidence I found that accompanies that monument. And I I found and accepted this monument as marking the corner. And then I document it, and I've got a record, and my measured happens to be 45 feet longer. It is what it is. Because it's my responsibility to report the dimensions. Now, do I write a new description of the property and try and crowbar it into the title record? Probably not. I'm in a recording state, so I record the survey because the only person that needs to know where the boundaries are and how to retrace the boundaries is the next surveyor. So I put my survey in the survey records so the next surveyor can find that survey and say, oh, 45 feet off. Wow, that's crazy. But yeah, here's all the evidence. He accepted it. And here it is. Now, if I can take that evidence and put it in the form of, say, a landowner's affidavit where they can now attest to the fact that they hired the surveyor, that hired you to survey the property, that you've found these discrepancies and they've accepted the location of your survey, and put that in the title record as in the form of an agreement or a boundary agreement, then yeah, more power to you, because now you've got at least something in the title record to perpetuate for title purposes. But it's not even an affidavit, doesn't really even affect the title. It just is throwing some information out there in the title records that says, oh, hey, by the way, you better go find a copy of this survey. And when you look at the survey, yeah, here's where the boundaries are. So it's just a matter of documentation, not really a matter of changing legal descriptions that are in the title record.
Thank you. I appreciate that answer, because that helps give confidence to surveyors, because we don't know sometimes, or untrained on what to do next, right? We find this error, and do we need to then go fix it? Do we not need to fix it? How do you do it? And this spiraling that I think happens. That's why surveyors do some of the stupid things we do, I believe, is because we don't know what's next. I know I've certainly felt that way in my career. As I found this, now what do I do? Because I don't want to practice law and tell my own clients or homeowners that, hey, you need to do this, this, and this next. And our job is to report it in the bounds that we've been talking about, or retrace it in the bounds we've been talking about. So wonderful. Thank you guys for that discussion. It looks like we found a free copy of that book online. So, okay, let's jump back into the book here. And for the shortest chapter, we're running out of time quickly. So this is a great discussion.
Yeah.
So we get into the statute of frauds and recording statutes. We talk about the Uniform Land Transaction Act, and how we can show this transfer of land. So under 4.05, the second paragraph, it says the American statutes are based on the English model, and while they vary in phraseology, they are similar in substance. There are three principal points of divergence. A, some statutes follow the New York style and make oral agreement void. Others simply say no action shall be brought. B, some statutes require that the agreement be subscribed. Others only that it be signed. And C, some statutes require that the agreement be signed by the party to be charged. Others that it be signed by the vendor, and at least one state, Idaho, has held the agreement unenforceable unless signed by both parties. The legal literature on the statute of frauds is a massive monument to man's attempt to reconcile the irreconcilable. And so we talk about this Uniform Land Act that was approved by the National Conference on Uniform State Laws to kind of help with that. And then jump into the end of this little section. I'm just going to read through all this to keep us moving, but it says, in addition to passing muster under the statute of frauds, the recording statutes that have been enacted by the states essentially make it a requirement that the deed be recorded. Although it appears to be very narrow be a very narrow exception to this rule, the general rule would be that an unrecorded deed will not be enforceable against a deed for the same property that has been recorded. There is no typical recording statute. Nevertheless, it is convenient as something of a simplification to say that most recording statutes fall within one of three categories: race notice, and notice. So I want to spend kind of the last little bit of the time we have talking about what these three statutes, these three rules are, and pairing that with the constructive notice there, and what that looks like in our states and how that applies to title. Anyone have any questions before we go on? Anyone want to throw any thoughts out there? We'll start talking about this. Okay, so the race. The first to the courthouse wins. Right? So we've got two deeds sold. If one sits for 10 years and then resells again and that one gets recorded, if I'm understanding this correctly, that second one, because it was the first in to actually be recorded and documented, that's the one that holds title to that land. Am I understanding that correct?
Yes, race statutes, it's first to the courthouse wins. It doesn't matter about notice, constructive notice, or actual notice. But there's only two states that I'm aware of, North Carolina and Louisiana, that has the race statutes.
Statute. Okay, and then
and as an attorney or a surveyor, maybe advising people to a certain extent with land transactions. I mean, don't walk, run, get your deed recorded. You're just asking for trouble to not get it recorded.
I think we've all had experiences where, Grandpa sold the 5 feet here because the neighbor needed a barn, and he sold it for goods and deeds, and everyone's known it, but now great grandson has it or grandson has it, and they've always kind of known it, but it's not in the record, right? It hasn't been recorded, and so always advising those to get fixed, recorded, and get that notice in there, right? Get it in the record. Okay, so the second one is race notice, also referred to notice race. And so notice, it says here in 4503 or 4053 was often referred to as a hybrid statute, is the race notice. About half the states have notice race statutes. These statutes require that the second grantee must do two things in order to prevail from the first: record before the first grantee, win the race, and 2, purchase without notice of the first grantee's claim. So not know that the first one happened. So is there any distinction there, anything that we need to clarify? I mean, obviously the first to win is the easy thing, but what about that notice that you don't know, the first one had a claim? How does that work out in the courts?
Well, actual notice is going to be tougher than constructive notice, obviously. Because actual notice, I mean, you got to be standing at the back door while the property's being conveyed on the kitchen table. And you got to actually see the conveyance happen. That would be actual notice. Constructive notice, there's already something filed. So if you go in, something's already been filed and you file, well, it's automatic. It's not your property. Now you probably have a fraud case against the grantor, for conveying the same property twice. But so constructive notice, not that big of a deal. Actual notice would be a little harder to prove, and maybe easier to get away with, on the other flip side of that coin.
Has there been? I just imagine that that's just a really hard thing to prove. Are there many cases or courts are actually looking at that second part of the hybrid?
Well, I don't know if I had the case in here or not. There's an Alabama case called Mosley versus Jefferson County, and they were building a Mosley's predecessor in title sold a right of way across the property to Jefferson County, I think, or it might have been Alabama Department of Transportation. No, I think it was Jefferson County. Sold a right of way and across the property, and then sold all of his property to Mosley, or sold all of his property. And when he sold all of his property, the grantee went and filed their deed, and then the highway department, like 2 years later, filed their right-of-way deed. So he was in court. He was conveyed the property without constructive notice of the road right of way, because the road right of way got conveyed after he bought property. And so he won at circuit court, and then it went up on appeal, and I guess the Court of Appeals overturned that decision because it had also come out in court that they had started building the road, even though they had not the county road department, even though the road department had not filed its deed after the conveyance of the property with no constructive notice of the right of way. They were actually out there building the road, so it was overturned, and he was charged with knowing. So you got to do your due diligence when you buy property. They were out there building the road, and even if he didn't go out there and see it, he had actual notice, or he had the opportunity for actual notice. So there was a real, that was a real case on the issue.
Okay, I like it. Thank you. Thanks for sharing that. So we've talked about actual and constructive notice a little bit here. We've got some clarity with that example there. So I think, is there anything else that anyone want to add about notice? I think that's, in my mind, it's fairly clear and easy to kind of understand in this, and we'll jump into some more.
Can I ask a quick question?
Yeah.
One, I have no idea how to raise my hand in Zoom. If you want to teach me that real quick, I won't interrupt.
It's I was gonna say
It's under React at the bottom. If you click React.
yeah, that's where it's at now.
Yeah. Oh, maybe not. I don't even know how to. That doesn't. Oh, raise hand right there. Yeah. It says
It's at the bottom of that bar. Okay, I missed that.
Yeah.
Okay, so my question regarding constructive notice is I've heard a few people say that records of survey in California basically don't provide constructive notice, and I've had a hard time understanding why. It seems to be a public document that is available and is showing boundary locations as determined by a surveyor. And if it doesn't provide constructive notice, how would you go about making it actually provide constructive notice is my question for somebody smarter than me.
Every state has a designated repository for their official documents. Okay, and it's the court of record or something to that effect. So in other words, in my state, it's the probate court. That's where all our records go. Now there's other documents that get filed in government, but there's no requirement. They might get deposited over with the Department of Transportation. They might get deposited with the right-of-way department down at the county, but they're not in the probate records where the official records of the state get, in the state get filed. So that's the court that for instance, the title companies have to go down and look in. That's where the chain of title is on property, and so there's a designated court for that. Now I understand that maybe some places where you file maps and somebody else would have to chime in on that, but there could be two repositories, one where surveys are recorded. Now, in my state, we also record the plats in the probate court. So the probate courts are your one and only stop.
So, John, I don't throw this out to you because I'm curious in Utah because we are one of those states. We have two repositories for survey, right? It's a separate filing. It doesn't get part of the actual title record there. Is in Utah, is that considered a public notice?
No, it's not. Well, the notice, there's a specific statute that, like Jeff is alluding to, that references your official repository for documents, and that repository is in Utah, the county recorder's office. And so there's a statute that provides statutory notice, not actual notice or constructive notice. It's actually noticed by statute. And the statute requires that if you've got a document that's in the recorder's office, then you should know it. You're required to. You're put on notice.
Hold the button down until it gets to the bottom.
Yeah, so you're put on notice with that filing. Now, in Utah, we file our surveys on a separate repository in the county surveyor's office. They are a public repository, but we do not have a statute that says that anything in the survey records is statutory notice or is noticed by statute. So the answer would be no on the surveys. We don't. It's not a. And that we did that intentionally because we don't want the title companies or even the clients to be bound by the survey information. Now, Montana, they record their surveys in the recorder's office. It's given an entry number and indexed in their title records. Because they have a statutory notice to the recorder's office, then it's actually the clerk and recorder's office. Then they've got a statute that would provide if you've got a survey in that record system, that would be actual notice as required by the statute.
Okay, thanks, John. That's what I thought, but I appreciate that clarity. Martina's got her hand up, and then David, I'm putting you on notice because I want to have you chime in a little bit more about California or anything there. So, Martina, go ahead.
Yeah, super short. I know I'm in Utah as well, so for any of you other guys that work in Utah now or someday, some title companies will look for surveys of record and they'll discover them. Some title companies don't. So just know that in Utah, if you see a title report shows a survey of record, don't assume that all title companies will look for surveys of record. That's it.
Yeah, the only reason you see them in the title report is because they put them in Schedule B, Section 2 and take exception to everything shown on the survey.
Yep, exactly.
David, do you want to throw any clarity or any more information about California there in kind of response to Kyle's question?
No, Kyle had a great question there, and I really didn't. I couldn't remember what the answer was, but I think we are the same as what you are in Utah. Yeah, all of our record of surveys are filed with the county surveyor's office, and he's right. Yeah, they don't show up in a title search. So I think everything that John said there is probably the same for what's in California.
Okay, great. Anyone else have any questions about their state or what they do or anything to add to that discussion? Wonderful. Okay, in the last couple minutes we have real fast, the chapter finishes out talking about, I'm just going to read some the top lines here. So title as an operation of law and equity. Talk about record title, marketable title, and insurable title. So record title is also conferred in essence by operation of law when an instrument of conveyance, a deed, is properly prepared, executed, and delivered. Marketable title. Black defines marketable title as title which is free from encumbrances and any reasonable doubt as to its validity, and as such is a reasonable, intelligent person who is well informed as to the facts and their legal bearing and ready and willing to perform his contract would be willing to accept an exercise of ordinary business prudence. And an insurable title is simple title that a reputable insurance company is willing to assure through the insurance of a title insurance policy. And that gets into some of our Alta surveys and stuff like that gets insured. So there's the 30-second rundown on those. David, you've got your hand up.
Yeah, thanks. Going back, sorry, before you get into those title circumstances, but going back to the maps on title searches, I had an interesting conversation this morning with an associate, and he brought up the idea this there's a situation where some of our title reports will have the map listed as an exception or a survey, and I said, well, yeah, that I think that's the smart money that puts the surveys as an exception on the title report, because they don't really know what whether that survey is something they want to insure, or if it's good, or what the surveyor's out to lunch or what. So if they have any sense, if they can find the survey, then they ought to put it on there as an exception. Otherwise they could get themselves in a pickle for somebody else's questionable boundary interpretation. But most of them don't show up. They list one every now and then. I guess if it's readily apparent, maybe if it's on the AP map or something, then they'll put it on there if it applies. But half the time, probably 3/4 of the time, the surveys are not referenced on the title survey. And I have seen several conflict situations where the title company is footing the bill for this boundary dispute between neighbors, and I think you got to get like the A grade title insurance for that to kick in. Most of us don't get that level of title insurance, but every now and then I get a call from a First American or somebody, and they want me to go out and retrace this boundary and figure out why the neighbors are fighting, and they pay. So that's all I wanted to say.
Thanks, David. We'll get into quite a bit more about those type of surveys and that stuff in some future chapters. I'll just throw this in my experience, when I have seen the survey exception on there, it's usually the first go around of title insurance, and then it's usually accepted out by the time they actually, as the lender, buyer, borrower, whoever it might be, they'll usually request that one to be removed, and I usually see that removed by the time I'm done with Alta surveys when I've seen that one on there. But on a few occasions they'll reference that, and they reference then my survey on there. But that'll be a great discussion. We are at time, so I just want to throw out there, Jeff, anything else you want to add into the three types of title we talked about. Anything I missed or need to hit real fast?
No, I think we got pretty much through it. Mm-hmm.
Okay. Look at that. 11 pages. Took us a whole time and then some.
That's
All
awesome.
right.
Great.
I would have never
Good
expected
job.
that. Never expected that. And you
I
had,
didn't either. I thought we'd go over those 10 pages in about 5 minutes.
I
And
know.
somebody's going to have to do a song and dance, and usually that's me.
I was going to say
You don't
Trent.
want that. You don't want that.
No, right? William said he got sick over the weekend, and you gave it to me, so that's why I have it now. So
Yeah.
I didn't chime
Everyone's
in.
got it. It's going everywhere right now.
I know. I didn't chime in much tonight. I was over here sneezing off all I could. So it's awesome.
All right, guys.
Well, good stuff. So December 4th, we'll start chapter 5. So that's gonna be a long one. So that's probably gonna take a few sessions to get through that. So
Yeah, I'm expecting so.
yeah. So
Chapter 5 is definitely
Everybody
my
have a
favorite
nice
chapter in the book. So tell
Yeah.
your friends, this is going to be a good one.
right, exactly.
Great. Have a great Thanksgiving, everybody.
You too,
All
everybody.
right. Happy Thanksgiving.
All right.
Thanks, everyone.
Bye, guys.
Goodbye.